Yeah, Trump made a deposition in August for this case, and yeah, we will see.
That were submitted by Mr. Trump and others. I am announcing that today we are filing a lawsuit against Donald Trump for violating the law as part of his efforts to generate profits for himself, his family, and his company. The complaint demonstrates that Donald Trump falsely inflated his net worth by billions of dollars to unjustly enrich himself and to cheat the system, thereby cheating all of us. He did this with the help of the other defendants, his children, Donald Trump Jr., Ivanka Trump, and Eric Trump, and former Trump Organization CFO Alan Weisselberg and Trump Organization Controller Jeffrey McConney. Mr. Trump and the Trump Organization repeatedly and persistently manipulated the value of assets to induce banks to lend money to the Trump Organization on more favorable terms than would otherwise have been available to the company, to pay lower taxes, to satisfy continuing loan agreements, and to induce insurance companies to provide insurance coverage for higher limits and at lower premiums. This conduct was all in violation of Executive Law, Section 6312, which gives the Attorney General broad and special powers to go after persistent and repeated fraud and illegality. As part of demonstrating illegality under that section of Law 6312, we show that they violated several state criminal laws, including falsifying business records, issuing false financial statements, insurance fraud, and engaging in a conspiracy to commit each of these state law violations. We believe the conduct alleged in this action also violates federal criminal law, including issuing false statements to financial institutions and bank fraud. And we are referring those criminal violations that we've uncovered to the United States Attorney for the Southern District of New York and the Internal Revenue Service. As a result of these violations, we are asking the court to, among other things, permanently bar Mr. Trump, Donald Trump Jr., Ivanka Trump, Eric Trump, from serving as an officer or director in any corporation or similar entity registered and or licensed in New York. To bar Mr. Trump and the Trump Organization from entering into any New York State commercial real estate acquisition or from applying for loans from any financial institution in New York for 5 years. To pay for the financial benefits obtained as a result of the persistent fraudulent practices at an estimated $250 million. And towards the end of my remarks, I will go into the other relief that we are seeking. At the center of the year-long financial scheme were the statements of financial condition that were prepared annually by and for Mr. Trump, specifically from 2011 to 2021. These statements were compiled by the Trump Organization executives and were issued as a compilation report by Mr. Trump's accounting firm. The statements are explicit that the preparation was the responsibility of Mr. Trump. Or starting in 2016, the trustees of his trust, Donald Trump Jr. and Alan Weisselberg, for the sole benefit of Mr. Donald Trump. Each statement was personally certified as accurate by Mr. Trump or by one of his trustees as part of the loan process, with the intent that the information in the statement would be relied upon by banks and insurers. Mr. Trump and Mr. Weisselberg would meet to review and approve the final statement every year. Mr. Trump made known through Alan Weisselberg that he wanted his net worth reflected on the statements to increase, a desire Mr. Weisselberg and others carried out year after year in their fraudulent preparation of the statements. And when asked about these meetings under oath as part of our deposition, both men, Mr. Trump and Mr. Weisselberg, invoked their Fifth Amendment privilege against self-incrimination, and they refused to answer. When asked under oath if he, Mr. Trump, continued to review and approve the statements after becoming President of the United States in 2017, Mr. Trump, again, invoked his Fifth Amendment privilege and refused to answer. Over the course of our investigation, we found that Mr. Trump, his children, the Trump Organization, created and used more than 200 false and misleading asset valuations on his statement of financial condition over that 10-year period. They issued statements that were in clear violation of general accepted principles in the general accounting principles in the United States, despite representing that these statements were prepared in accordance with these principles. Some of the common tactics they used include representing that Mr. Trump had cash on hand that he did not have, ignoring critical restrictions that would significantly impact property values when setting valuations, changing the methodology used to value properties from year to year without reason or notice, and using vastly different methods to value different properties even in the same year, and including tangible items such as brand premiums, the Trump premium, when calculating an asset's value, despite the fact that they ignored the advice of outside professionals. They also ignored the advice and appraisals of outside professionals, despite claiming those individuals provided certain figures. For example, they received a series of bank-ordered appraisals for the commercial property at 40 Wall Street in New York City that calculated the value of the property at $200 million as of August 2010, and $220 million as of November 2012, yet with a value of $524 million, which increased to $530 million over the next 2 years, more than twice the value calculated by the professionals. Even more egregious, the $500 million plus valuation was attributed to information from the appraiser who valued the building at just over $200 million. Another deceptive strategy they employed was to use objectively false numbers to calculate property values. Take Mr. Trump's triplex. You know, the triplex apartment in Trump Tower on Fifth Avenue? Mr. Trump represented that his apartment spanned more than 30,000 square feet, which was the basis for valuing the apartment. In reality, the apartment had an area of less than 11,000 square feet, something that Mr. Trump was well aware of. And based on that inflated square footage, the value of the apartment in 2015 and 2016 was $327 million. To this date, no apartment in New York City has ever sold for close to that amount. Tripling the size of the apartment for purposes of the valuation was intentional and deliberate fraud, not an honest mistake. Mr. Trump was intimately familiar with the layout of both the building and the apartment, having personally overseen the construction of both. Despite his sworn testimony before invoking his Fifth Amendment privilege, Mr. Weisselberg conceded that using the false square footage improperly inflated the value of the apartment almost threefold. Mr. Weisselberg admitted that this amounted to an overstatement of, give or take, $200 million. Misrepresenting the size of the apartment was only one of the many ways that Mr. Trump intentionally misvalued his asset for the purposes of increasing his net worth and inducing banks to offer more favorable terms. Mr. Trump also routinely ignored legal restrictions on development rights and marketability on properties that would significantly decrease property values. For example, let's take Trump Park Avenue in New York. This building contains both commercial and residential space. The unsold residential condo units owned by Mr. Trump and the Trump Organization represented the lion's share of the reported value for this property. Mr. Trump and his children intentionally ignored legal restrictions on some of the units that would have drastically changed the valuation. Specifically, the 12 of those units were actually rent-stabilized apartments. A professional appraiser valued those 12 units at around $750,000, noting that the rent-stabilized units cannot be marketed as individual units for sale because the current tenants cannot be forced to leave. Despite this professional valuation, and Mr. Trump knowing full well the legal restrictions the 12 rent-stabilized units were valued, he valued them collectively on his statements at $49 million. That is about 65 times the appraised valuation. Mr. Trump also blatantly ignored legal restrictions at Mar-a-Lago. Mar-a-Lago was valued on the false premise that it sat on unrestricted property and could be developed for residential use. However, Mr. Trump knew that Mar-a-Lago was subject to a host of onerous restrictions and limitations. Mr. Trump himself signed deeds sharply restricting changes to the property and donating his residential development rights in an effort to get a tax deduction and later to lower his property taxes on the property. The deeds also require Mr. Trump to donate over 23% of Mar-a-Lago's value to the Historic Trust for Historic Preservation if he ever sold it. Despite these significant restrictions, Mr. Trump valued the property based on the false premise that it was an unrestricted residential 18-acre plot of land that could be sold and used as a private home. In fact, the valuations represent that these restrictions don't even exist. The club generated annual revenues of less than $25 million and should have been valued at about $75 million. However, Mar-a-Lago was valued as high as $739 million. Mr. Trump used inappropriate schemes to inflate the value of his other golf clubs. He valued the clubs based on their fixed assets. In other words, the money spent to acquire and to maintain them, despite being informed by valuation professionals that this practice was inappropriate for a club operating as an ongoing business. He again added a brand premium when determining the value of the club, but claimed in his statements that he did not. And he inflated the value of unsold memberships, often by hundreds of thousands of dollars per membership, even in situations where the memberships were given away for free at Mr. Trump's direction. Inflating his reported net worth was just the first part of the scheme. He then used these false statements of financial condition for his own personal gain. Mr. Trump and the Trump Organization have obtained hundreds of millions of dollars in real estate loans and insurance coverage using these statements. Mr. Trump was able to secure much more favorable loan terms by personally guaranteeing the loans based on his reported net worth, as reflected on his statements of financial condition. These statements were integral to Mr. Trump and the Trump Organization's ability to secure loans for a number of properties, including the old post office in Washington, D.C. Mr. Trump's statements were first submitted to the federal government to demonstrate his financial status, his net worth. He then engaged with Deutsche Bank to obtain a loan to redevelop the property. Mr. Trump was able to obtain much more favorable loan terms by personally guaranteeing the loans. So in 2014, he secured a loan from Deutsche Bank for $170 million. And as you know, in May of 22, Mr. Trump and the Trump Organization, they sold the post office, the old post office property, for $375 million, resulting in a $100 million net profit, which was the result of a loan he was able to obtain through the use of false and misleading statements of financial condition. Separately, Mr. Trump and the Trump Organization saved an estimated $150 million by receiving favorable interest rates that were only provided based on the false and misleading statements of financial condition. We also believe that he illegally saved millions of dollars in federal tax benefits, conservation easement donations related to Seven Springs in Westchester and the Trump National Golf Club in Los Angeles. And this conduct is not the subject of this action, but we are referring it to the IRS and to the Southern District of New York. The examples I laid out just barely scratch the surface of the misconduct that we have uncovered. The complaint, which all of you should have a copy, is more than 280 pages long. It includes examples from 23 assets that were grossly and fraudulently inflated, and those inflated values were used on Mr. Trump's statements almost every year. All told, we uncovered more than 200 examples of false and misleading asset valuations that were used on his statements. The pattern of fraud and deception that was used by Mr. Trump and the Trump Organization for their own financial benefit is astounding. Inflating the values of assets by whatever means necessary to increase Mr. Trump's purported net worth. And then that net worth was used to further enhance his financial standing, intentionally misrepresenting his financials to obtain incredible economic benefit. It was a scheme that, by its very nature, became more profitable over time. And it is all in stark violation of the law. As I mentioned earlier, the relief that we are seeking specifically, we are asking the court, again, to permanently bar Mr. Trump, Donald Trump, Eric Trump, Ivanka Trump, from serving as an officer or director in any corporation or similar business entity registered or licensed in New York State. We are barring Mr. Trump and his organization from entering into any New York State commercial real estate acquisition for 5 years. We are barring Mr. Trump and the Trump Organization from applying for any loans from any financial institution registered with the New York Department of Financial Services for 5 years. We are requiring Mr. Trump and the Trump Organization to disgorge the financial benefits obtained through the persistent fraudulent practices, an estimated baseline at the minimum of $250 million, and to appoint an independent monitor at the Trump Organization to oversee compliance, financial reporting, valuations, and disclosures to lenders, insurers, and tax authorities for no less than 5 years. We are requiring the Trump Organization to prepare on an annual basis for the next 5 years a GAAP, a generally accepted accounting practices compliant audited statement of financial condition showing Mr. Trump's net worth to be distributed to all the recipients of his prior statements of financial condition. To replace the current trustees of the Donald J. Trump Revocable Trust with new independent trustees, or require similar independent governance if a new trust is created. And to permanently bar Alan Weisselberg and Jeffrey McConney from serving in the financial control of any New York corporation. And lastly, to cancel any certificate filed under and by virtue of the provisions of Section 130 of the General Business Law for the corporate entities named as defendants and any other entity controlled by or beneficially owned by Donald Trump, which participated in or benefited from the ongoing financial scheme. In other words, permanently prohibit any of these companies from doing business in the state of New York. I want to be clear. White-collar financial crime is not a victimless crime. When the well-connected break the law to take in more money that they are entitled to, it reduces resources to working people, to regular people, to small businesses, and and all taxpayers. Everyday people cannot lie to a bank about how much money they have in order to get a favorable loan to buy a home or to send their kid to college. And if they did, the government would throw the book at them. Why should this be any different? It is a tale of two justice systems, one for everyday working people and one for the elite, the rich and the powerful. Mr. Trump and his allies may say that these penalties are too harsh or that this is part of a witch hunt. I will remind everyone that this investigation only started after Michael Cohen, his former lawyer, testified before Congress and shed light on this misconduct. And the remedies are consistent with what we have sought for other businesses that committed the same misconduct. This investigation revealed that Donald Trump engaged in years of illegal conduct to inflate his net worth, to deceive banks and the people of the great state of New York. Claiming you have money that you do not have does not amount to the art of the deal. It's the art of the steal. And there cannot be different rules for different people in this country or in this state. And former presidents are no different. And so today we are making good on that promise and our commitment, because no one is above the law. And I would like for them to stand. This investigation was led by Senior Enforcement Counsel Kevin Wallace, Senior Counsel Andrew Amer, Assistant Attorney General Colleen Faherty, Assistant Attorney General Alex Finkelstein, Assistant Attorney General Will Handley, Assistant Attorney General Stephanie Torre, Assistant Attorney General Austin Thompson, Special Counsel to the Solicitor General Eric Herron, Enforcement Section Chief Louis Solomon, Legal Support Analyst Samantha Stern. Additional support was provided by a data analyst, Anusha Chowdhury, Senior Data Analyst, Akram Hashinoff, Data Scientist, Chun-Soo Song, Deputy Director of Research and Analytics, Megan Thorsfeld, Director of Research and Analytics, Jonathan Werberg, as well as Information Technology Specialist, Yu-Sing Chin, and Information Technology Specialist, Paige Puldoni, Information Technology Specialist, John Roach. Appellate support was provided by Deputy Solicitor General Judy Vale, Assistant Solicitor General Eric Del Pozo, all under the oversight of First Deputy Attorney General Jennifer Levy. I thank you for your service. You may have a seat. Now I know that I've provided you with a lot of numbers, a lot of property. Members of the team will be available to answer any specific questions, but at this time I'm going to turn it over to Delaney, who's going to lead the Q&A on on-topic questions. Thank you. Delaney?
Yeah, so, hey,
Sorry, can I just introduce yourself and say your own?
Sorry, Jonathan Deans with NBC.
Yeah.
I wanted to ask, you say that there was criminality involved here. I was wondering if you've referred this to the Manhattan DA as well. You've been part of that investigation. And should we expect to see state charges out of the Manhattan DA's office?
As you know, there was a parallel criminal investigation being conducted by the District Attorney of Manhattan. And we are cooperating with the Manhattan District Attorney, and any information that he is requesting, we will submit it to his office. We cooperate with any law enforcement agency, including but not limited to Manhattan DA. Thank you.
Adam Reese, NBC.
said that his career and his empire was basically a sham and smoke and mirrors. Can you just describe, are you trying to shut him down, and where do we go from here?
So, again, this investigation has to do with his statements of financial condition over a period of 2011 to 2021. And this is an attempt to seek redress for the taxpayers of the great state of New York, for individuals in the great state of New York. And he could reconstruct and reorganize a number of these corporations, but the relief that we are seeking from this judge is, again, for him to reform his practices in the state of New York and to prohibit him from engaging in any real estate commercial transactions in the state of New York going forward.
As you note these, I apologize, Henry Rossoff with Pix 11. As you note, these allegations are at least 3 years old. That's the origin of your investigation. The DOJ and IRS have had access to the same starting points that you did. With these referrals, do you hope to force their hand into action?
It's not a question of forcing their hands. It's a question of presenting to them evidence, which we believe suggests illegality and suggests that he was engaging a number of schemes to benefit himself, his corporation, his family. And so we will present this information to the District Attorney of New York if he requested, as well as the Southern District of New York and the IRS, based on the allegations that we have covered, based on the evidence that we have covered.
CNN. Are you willing to settle with the Trump Organization, and if so, what terms would be appropriate and favorable for you that you would agree to settle?
I will not negotiate in public, and as you know, as been publicly reported, we rejected settlement offers that they submitted, and our doors are always open.
Washington Post. It's been suggested by Mr. Trump and his advocates that they were engaging in standard practices. This is standard in the real estate business. How is what they were doing different from standard practice here? And can you comment on that defense that
So
he's offering?
This conduct cannot be brushed aside and dismissed as some sort of good faith mistake. The statements of financial condition were greatly exaggerated, grossly inflated, objectively false, and therefore fraudulent and illegal. And as a result of that, we are seeking relief, and Mr. Trump, the Trump Organization, his family, they should all be held accountable. And that is the purpose of this litigation that we are filing today, in addition to referring the criminal conduct to the Southern District of New York, as well as the IRS. No one, my friend, is above the law.
Marcia Kramer from CBS, Madam Attorney General. I have two-part question. Number one, is there anything to prevent Mr. Trump from establishing his corporations, even for the properties in New York, in another state, since he is now become a legal resident of Florida? And secondly, you called it, Donald Trump Jr. has already started tweeting that this, quote, the Democratic witch hunt has begun, if you'd like to respond to that as well.
So with regards to the name calling, as you know, they've basically have attempted to delay this investigation, and two judges have dismissed those claims that this was a political witch hunt. So I give no credence to those names that he's referred to me. And two, Mr. Trump, the Trump Organization, as well as his family, will still have to deal with this complaint. They will still have to respond. They will still have to respond to the allegations therein. And so if, in fact, he decided to move to Florida, the reality is he still has to deal with the great state of New York and respond to the complaint.
But he can't establish another corporation, put these properties in a corporation that he incorporates in another state?
No, he cannot.
Any state other than
Correct. These corporations are currently incorporated in the state of New York. Some are incorporated in Delaware, but they do business in the state of New York. And he cannot just pick up and those same corporations can be moved to Florida. No. And again, Marcia, just to put a finer point on that, we are attempting, as part of our relief, to dissolve these corporations.
Laura Italiano from Insider. In practical terms, much of former President Trump's biggest money-generating properties are in Manhattan, in New York estate, would he, if this relief is granted by the judge down the road, would he be able to collect rents, to obtain loans on the properties? What precise, what practical implications to sell the properties should he want to? Is the incorporation that's filed in New York necessary for him to do those things?
So again, most of the corporations have been incorporated in the state of New York. There are some that have been incorporated in Delaware, but they continue to do business in the state of New York. We are permanently barring Mr. Trump and his family members from serving as an officer or director in any entity in the state of New York. We are barring him from entering into any commercial real estate transactions for 5 years. We are barring Mr. Trump and the organization from applying for any loans for 5 years, just for 5 years, requiring him to repay the financial benefits of $250 million, placing a monitor over these corporations, requiring him to file a GAAP-compliant statement of financial condition, replacing the trustees, if in fact he creates a new trustee, and permanently barring Alan Weisselberg and Jeffrey McConney, and canceling his certificate of incorporations for those corporations that we've discussed. Yes.
Are these relief that a judge would have to approve?
Yes.
So these things aren't happening at the moment,
Correct.
but this is what will be litigated now down the road.
Correct. And it's important also to understand that Mr. Trump will continue to have a financial interest in a lot of these corporations. And so if he decides to, at some point in time, sell them, or if he decides to restructure them, again, this is all part of the relief that we are seeking. I said to Marcia that we're seeking to dissolve them. That was incorrect. We're not seeking to dissolve them. He still has a financial interest in these businesses and corporations. Correct.
However, to collect rent, to obtain a loan based on them as collateral, to sell the property, maybe I'm missing some other practical things. If approved by a judge down the road, these are things he would not be able to do with those properties.
Correct. For the next 5 years.
Can I take some more questions?
Josh Gerstein with Politico.
Yeah.
Madam Attorney General, can you explain something about how the former president, you allege he did this for at least a decade or more than a decade. How did he get away with what you're saying he got away with for such a long period of time? A lot of these transactions are with some of the largest financial institutions and insurance companies in the state of New York. Did they just not check anything that people tell them, or they presumed it was true, or did they have hints that these things were not true that they were being told? And what does it tell you about those institutions that they would take his word for it?
So let me just say, with respect to Ms. Orrs indicated on the statement of financial condition they did not certify and they did not audit these statements. That does not absolve Mr. Trump of submitting accurate information. 2, with respect to Cushman Wakefield, there is an ongoing investigation into Cushman Wakefield. And then lastly, with respect to Deutsche Bank, we're in conversations with Deutsche Bank. They have been cooperating with our office.
Last question is maybe for you. Do you feel like this lawsuit is going to be resolved quickly, or do you feel like this is going to be a drawn-out process?
So that's entirely up to the judge. Thank you all for coming, and if there's any specific questions, I believe the members of the team will answer your questions. Thank you.
So what new
Okay, as I understand, this trial will be in October this year. Yeah, we will see what happens until then. There are a lot of depositions. Just yesterday, I think, the Attorney General of New York, Letitia James, filed a complaint because before the judge to sanction Trump and his lawyers because they made false statements and in contradiction to earlier statements they made on those and stuff like this. So there are a lot of stuff around this, but I will try to not do all of it. It's just too much, and yeah, you will find everything on the internet. So let's check if what other Trump legal investigations he has, and then we watch the deposition.
Reporting do we have about how that investigation is going?
Yeah, Allison, so there are 3 major criminal investigations swirling around Donald Trump right now. We've been here before, the investigation swirling phase. None of them have resulted in indictment. So let's take stock starting with that Justice Department investigation.
I think they don't have this investigation because it's a civil suit and not a criminal investigation. As she told, she will refer to criminal investigators and prosecutors, but yeah, this is civil suit. So I think that's a little bit important because later when he invokes the Fifth Amendment, I think that has implications for a civil suit.
It was 73 days ago, I counted, when Merrick Garland appointed Jack Smith as special counsel. Now, Jack Smith has 2 jobs to investigate January 6th, first of all. We've not actually seen any movement on that lately. Could be happening behind closed doors. And then to investigate the Mar-a-Lago documents scandal. As you said, we now have new reporting from our 2 Caitlins, Polance and Collins, that 2 people have gone into the grand jury who recovered some of those documents for Donald Trump. That tells us that Jack Smith continues to move ahead in that part of the investigation. Now, how's this going to play for now? When Jack Smith is ready, he will make a recommendation to the Attorney General. Indict or don't indict. The final word, however, is up to Merrick Garland. By law, he has to give Jack Smith's recommendations, quote, great weight. So we'll see how this plays out. Ultimately, this will be up to Merrick Garland.
Of course, there's the DA, Fani Willis in Georgia, who is looking into former President Trump's alleged efforts to overturn the election in that state. How could that affect the 2024 presidential campaign?
Yeah, Victor, well, this could be the most immediate case of all the pending cases. The district attorney, we found out in the last couple weeks, she has finished her presentation to the special grand jury. Now, we're not seeing that report as of this moment. The special grand jury cannot indict, but what the special grand jury can do is make a recommendation. Ultimately, again, it will be up to Fani Willis whether she wants to go to a regular grand jury to seek an indictment. Now, we did get an interesting indicator recently. Fani Willis said in court to a judge that, quote, decisions are imminent. Now, people ask me, what is imminent? Is that some sort of legal technical word? No, it just means imminent. It just means soon. Whatever Fani Willis thinks is soon is soon. But I would take her at her word, and I think we will hear fairly imminently what her decisions are.
Ellie, how about that hush money payment to Stormy Daniels? Is that back again?
Well, this is the oldest and the newest. This dates back to 2016, but there are brand new developments here. We've just learned that the New York DA, the Manhattan DA, a state-level prosecutor here in Manhattan, is going to put evidence of these hush money payments in front of a grand jury. That could result in an indictment. And it's interesting because this goes back so far in time. And I think the question is, what has happened? This goes back 6.5 years to before the 26 campaign. Why now? And will the grand jury see fit to indict? And if so, we're talking about New York state level crimes here. That is a really surprising new development and one that we're going to have to watch really carefully.
There are new developments tonight in
Is that correct?
Same answer.
Yeah, so as you see, this was in August, and he didn't say much, so he made a statement and then said not much. We will watch.
Good morning. You're going on the record at 9:38 a.m. Eastern Daylight Time on August
10th, 2022. Please note that the microphones are sensitive and may pick up whispering and private conversations. Please mute your phones at this time. Audio and video recording will continue to take place unless all parties agree to go off the record. This is Media Unit 1 of the video recorded deposition of Donald J. Trump, taken by counsel in the matter of financial statements and investigation for the state of New York, Office of Attorney General. The location of the deposition is 28 Liberty Street, New York, New York. My name is Zeph Koda, representing Veritex, and I am the videographer. The court reporter is Linda Greenstein from the firm Veritex. I am not authorized to administer an oath. I am not related to any party in this action, nor am I financially interested in the outcome. Counsel and all present, including those remotely, have been noted for the record. Will the court reporter please swear in the witness, and then counsel may proceed.
Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning, Mr. Trump. My name is Letitia James, and I'm the Attorney General of the great state of New York. Before we begin, if everyone would please silence their cell phones, we would appreciate that. I wanted to begin with some preliminary rules, some ground rules,
Sure.
if you don't mind, and then I'm going to turn it over to Kevin to conduct this examination. Mr. Trump, you've testified under oath many times. Is that correct?
Yes.
And so I take it you are familiar with the ground rules on for how testimony proceeds. Is that correct?
Yes.
Okay. So I'll skip that part of the introduction. Is that okay?
Sure.
Okay. And are you okay right
I
now?
am.
Okay. Good. What I will do is explain some differences between the procedures in a civil deposition and the testimony we are taking today, because this is an investigatory proceeding. You do not have a right to have an attorney with you in this investigation, but I have agreed that your attorney will be present today. However, this examination is not the same as a deposition in ordinary civil litigation, and your attorney's role will be limited to consultation with you in order to give you legal advice regarding privileged matters, if any, or your right not to incriminate yourself. Notwithstanding any objection by your attorneys, you are still required to respond to any questions unless your attorney specifically directs you not to answer. Anything you say in this examination may be used in a civil proceeding, and that can include a civil enforcement proceeding or a criminal action. Do you understand that?
I think.
Is that a yes?
I don't know what I did wrong, but the answer is yes, I do understand.
Thank you. You have the right to refuse to answer any question if a truthful answer to the question would tend to incriminate you. Do you understand that?
Yes.
Okay. And any willful misstatement by you may constitute perjury. Do you understand that, sir?
Yes.
Okay. Finally, this investigation is confidential. We request that you not discuss this matter, your testimony here today, and any documents that you have produced or may produce in connection with today's testimony with anyone other than your attorneys. Do you understand that, sir?
No. When you say confidential, we're not allowed to talk about this to the press, or?
Correct.
I believe what she
Sorry.
means is what happened in this room, the details of what happened in this room.
Okay.
Obviously,
It's okay with me.
Yeah.
And the fact that it happened, yes, but not the details.
Okay.
Neither you nor anyone acting on your behalf has the right to obtain a copy of the transcript of your testimony here today from the reporter. And neither you nor Veritex are permitted to release copies of the transcript to anyone other than representatives of this office, the Office of the Attorney General. Extensive note-taking or any attempt to create a transcript of the proceedings here by you or your attorneys is not authorized and will not be permitted. Are you taking any medication or drugs of any kind that make it difficult for you to understand or answer any of the questions today, sir?
No. An aspirin.
And are you feeling okay?
Already perjured.
Today?
Yes.
And are you sick today?
No.
Okay.
And do you have any conditions that could prevent you from giving full, complete, and truthful answers to any questions today?
No.
And is there any other reason why you cannot give full, complete, and accurate testimony here today?
Well, you have to, I'll be doing this.
Yes. No.
No, other than what I'm saying.
Okay. I'm now going to turn it over to Kevin Wallace. Thank you, sir.
Thank you.
Good morning, Mr. Trump.
Good morning.
As the Attorney General mentioned, my name is Kevin Wallace. Sitting next to me is Alex Finkelstein from our office. And sitting next to him is Samantha Stern, who's a paralegal with our office. They're going to be assisting me during the day today. I'm going to take a moment just to correct one thing from the read-in, is that we go off the record not when both parties agree, but when the Attorney General directs that we are off the record. During these proceedings, the Attorney General controls the record. Mr. Trump, what did you do to prepare for today's examination?
You can start. You can read your sentence.
Very little.
Read your statement.
If you'd like, I could read the statement, but very little.
Well,
excuse me.
Read the statement.
can we go?
Yes, he would like
I will
to.
now use my moment to go off the record.
Thank you. Sorry. Just read the statement.
We're going off the record at 9:44 a.m. We're back on the record at 9:45 a.m.
Mr. Trump, I understand you have a statement that you wanted to read into the record.
Yes.
Would you please feel free to start at any time?
Thank you very much. This is the greatest witch hunt in the history of our country.
What a way to start.
There has never been another president, or perhaps even another politician, who has been persecuted, harassed, and in every other way unfairly treated like President Donald J. Trump. What Letitia James has tried to do the last number of years is a disgrace to the legal system, an affront to the New York State taxpayers, and a violation of the solemn rights and protections afforded by the United States Constitution. She developed a political platform and made a career out of maliciously attacking me and my business before she even understood or was elected or reviewed one of the millions of pages of documents we willingly produced. We willingly produced these documents. James proclaimed that she, quote, looks forward to going into the office of Attorney General every day suing me and then going home. This is during her campaign. She announced that she was obsessed with, quote, taking me on, and that her eyes were set on Trump Tower, quote, Trump Tower. She even assured her supporters as an election promise very strongly that, quote, we're going to definitely sue him. Before she even knew anything about me, we're going to be a real pain in his ass. He's going to know my name personally. And she claimed I was on an illegitimate, and that it was an illegitimate president. Quote, illegitimate president. In her AG speech, she promised to, quote, shine a bright light into every dark corner of Trump's real estate holdings.
So I'm not sure how the Attorney General is chosen. New York. So it is an election. Yeah. Okay, the people in the state. So I think it's kind of fine to say what you want to do as Attorney General. So this is kind of, yeah, just blah, what he's saying.
Shortly thereafter, she vowed to, quote, use every area of the law to investigate President.
Yeah, she's using every area of the law to investigate. I mean, that should be the case.
Trump and his business transactions, and that of his family as well. She knows nothing about us. This is when she knew absolutely nothing about us. It was very unfair. This whole thing is very unfair. As a pretense for commencing her bogus investigation, Letitia James relied on the testimony of Michael Cohen, a convicted felon and liar.
And your lawyer for a long, long time.
The Southern District of New York astutely described Cohen as a man who, quote, repeatedly used his power and influence for deceptive ends.
And to pay hush money for your affair with Stormy Daniels, that it doesn't come out in the 2016 election, before the election.
Engaging in, quote, extensive, deliberate, and serious criminal conduct consistent with a, quote, pattern of deception that permeated his professional life. This was in a...
And he went to jail for it because you directed him to do it.
Long, many-page statement by him. It only gets worse. This is the witness, a stone-cold loser, a real loser, that she used to justify her obsessive work, her obsessive investigation of me, even though he got in civil and criminal trouble for representing himself on a taxi cab company that he had and other things, and also others as a lawyer. I once asked, if you're innocent, why are you taking the Fifth Amendment? I was asking that question. Now I know the answer to that question. When your family, your company, and all the people in your orbit have become the targets of an unfounded, politically motivated witch hunt,
Yeah, everything is a witch hunt. I mean, of course, the prosecutors want to get you when you're indicted or investigated. So it's every single case that you're the bad guy in this situation. So it makes this argument makes no sense. Still holds if you're honest. If you just did nothing wrong, the Fifth Amendment, why would you do it?
Supported by lawyers, prosecutors, and even the fake news media, you really have no choice. We cannot permit a renegade and out-of-control prosecutor to use this investigation as a means of advancing her political career. New York deserves better, and this country deserves better. Being a prosecutor is a very important thing. This is a vindictive and self-serving fishing expedition, the likes of which this country has perhaps never seen before. If there was any question in my mind, the raid on my home 2 days ago, Mar-a-Lago, Palm Beach, Florida, by the FBI, just 2 days prior to this deposition, think of it, wiped out any of that uncertainty. I have absolutely no choice because the current administration and many prosecutors in this country have lost all moral and ethical bounds of decency. Anyone in my position...
A lot of decisions made in all these cases are by Trump appointees as well. So it's like just ludicrous to say it's all the bad legal system and stuff like that. That especially in the Mar-a-Lago case with the documents, he tried to litigate some of this stuff, and the Trump lawyers get smacked or tried to do something. Yeah, I can't do all the details here because like when the video would be 1,000,000 hours, but I think in the coming month and years before the election, we will see a lot of this stuff coming up again and will be discussed.
Not taking the Fifth Amendment would be a fool, an absolute fool.
There he is right. I mean, as I said earlier, the Attorney General used some earlier depositions he made against him because he was just inconsistent and trying to change what he said earlier. And yeah, because he is like not the smartest guy in the world, I would say. He has, and they're just not honest. It's hard to cover your lies over all these years, so it's better for him to say nothing, of course.
One statement or answer that is ever so slightly off, just ever so slightly, by accident, by mistake, such as it was a sunny, beautiful day when actually it was slightly overcast, would be met by law enforcement at a level seldom seen in this country. Because
I mean, this example is just, I mean, what is it? He said the weather was sunny and it wasn't. What the fuck is going on?
Experienced it. The United States Constitution exists for this very purpose, and I will utilize it to the fullest extent and defend myself against this malicious attack by this administration, this Attorney General's office, and all other attacks on my family, my business, and our country. Accordingly, under the advice of my counsel and for all of the above reasons, I respectfully decline to answer the questions under the rights and privileges afforded to every citizen under the United States Constitution. This will be my answer to any further questions.
I'm not sure about this, but I think in a civil suit, if you evoke the Fifth Amendment, it can hold against you a little bit. But I'm no lawyer, so I have no idea really. But I think I heard in a criminal suit, there's nothing that come from this. But in a civil suit, it could be a problem. But I'm not sure about that.
Include among the rights and privileges afforded every citizen under the United States Constitution, does that include the Fifth Amendment right to avoid incrimination?
Yes.
So your counsel?
Yes.
Okay. Okay. I will just note for the record that was a lengthy statement. Obviously, we disagree with all of the characterizations, but to keep today's proceedings moving, I'm going to move on to my questioning. So, Mr. Trump, I take it you are not going to answer any questions about your preparation today with your counsel. Is that correct?
Then, should I say this, or should I respond to that?
Just read that.
For all of the reasons provided in my answer, which is incorporated herein in its entirety, I decline to answer the question.
Mr. Trump, the focus of our investigation and what we are primarily going to cover today involves the presentation of your statements of financial condition between 2011 and the present. I take it you are generally familiar with those statements. Is that correct?
For all of the reasons provided in my answer, which is incorporated herein, in its entirety, I decline to answer the question.
Okay. Did you review any of those statements from the period 2011 to 2021 during your preparation for today's testimony?
For all of the reasons provided in my answer, which is incorporated herein, in its entirety, I decline to answer the question.
Counsel, I think we can all stipulate that if he says same answer, we will all understand it to be the same invocation.
That's correct.
To speed things up. Okay.
No problem.
I think they should made him to say this sentence the whole day. They made like a 4-hour deposition, I think. It would probably take then like 8 or 10, but it would be funny. And it is kind of funny. But yeah, now we will hear only the same answer stuff. I will just let it play out because you see semantics and some documents provided to him and stuff like that. So I just let it play it out. It's 20 minutes, so it's not much news now, but I still will let it play out.
With that note, sir, you are currently the president of the Trump Organization. Is that correct?
Same answer.
And when I refer to the Trump Organization, is it accurate to describe that as the trade name for an umbrella organization that holds assets beneficially owned by you?
Same answer.
Is it fair to say that the Trump Organization sits on top of several hundred different legal entities?
Same answer.
Are the assets of the Trump Organization currently held in a revocable trust?
Same answer.
Is that revocable trust the Donald J. Trump Revocable Trust dated April 7, 2014?
Same answer.
And you are the donor of the assets in that trust, is that correct?
Same answer.
And you are the sole beneficiary of the assets in that trust, is that correct?
Same answer.
Why did you form that trust in April 2014?
Same answer.
Who were the trustees when the trust was first founded?
Same answer.
At some point, Alan Weisselberg and your son, Don Jr., were the trustees, is that correct?
Same answer.
Did you ever consider retaining independent trustees to oversee the trust?
Same answer.
At present, your son, Don Jr., is the sole trustee, is that correct?
Same answer.
Right. Thank you.
Mr. Trump, the court reporter has handed you a document. It is a printout of an Excel spreadsheet, so it doesn't have a document number on it. But I'll represent to you that it is the supporting spreadsheet for your statement of financial condition for the year June 30, 2011. Do you recognize the form of this document?
Same answer.
This is the supporting data spreadsheet that was used to prepare your 2011 statement of financial condition. Is that correct?
Same answer.
The spreadsheet is used to calculate the valuations contained in the statement of financial condition. Is that correct?
Same answer.
You reviewed this document with Alan Weisselberg before it was finalized as part of the 2011 statement of financial condition. Is that correct?
Same answer.
You reviewed this document with Jeff McConney before the 2011 statement of financial condition was issued. Is that correct?
Same answer.
You reviewed and approved the valuations and valuation methods contained in this document before it was finalized. Is that correct?
Same answer.
And you approved the valuations and valuation methods contained in this document before it was finalized. Is that correct?
Same answer.
The valuations contained in this document reflect false and misleading valuation statements. Is that correct?
Same answer.
You were aware at the time this was finalized that the statement of financial condition for 2011 contained false and misleading statements. Is that correct?
Same answer.
In preparing the 2011 statement of financial conditions, Alan Weisselberg and Jeff McConney worked at your direction and followed your instructions and inflated asset valuations on the statement of financial conditions by employing false or misleading assumptions. Is that correct?
Same answer.
From at least 2005 through the present, you've had an ongoing agreement with Mr. Weisselberg and Mr. McConney that they would prepare the statement of financial condition in a manner that included valuations that depended on false and misleading assumptions as a means of inflating reported values. Is that correct?
Same answer.
From at least 2005 through the present, you have had an ongoing agreement with Mr. Weisselberg and Mr. McConney and others that they would prepare the statement of financial condition in a manner that included intentional overvaluations. Is that correct?
Same answer.
From at least 2005 through the present, you have had an ongoing agreement with Mr. Weisselberg and Mr. McConney and others that they would prepare the statement of financial condition in a manner that included false and misleading valuations statements. Is that correct?
Same answer.
Can we go off the record for 1 sec?
We're going off the record at 1:51 p.m. Can we just do this thing?
We're at 29, right?
We're back on the record at 1:53 p.m.
Mr. Trump, we don't have a hard copy of the next document, but I'm going to designate the document that is up on the screen as Exhibit 29. This is an electronic copy of the supporting spreadsheet for your statement of financial condition. It bears the production number, let me say, the document bears the production number, Mazars NYAG 00161836. Do you recognize the form of this document?
Same answer.
This is the supporting data spreadsheet for the 2019 Statement of Financial Condition. Is that correct?
Same answer.
This spreadsheet was used to calculate the valuations contained in the Statement of Financial Condition. Is that correct?
Same answer.
You reviewed this document with Alan Weisselberg and your son Don Trump Jr. before it was finalized as part of the 2019 Statement of Financial Condition. Is that correct?
Same answer.
You reviewed and approved the valuations and valuation methods contained in this document before it was finalized. Is that correct?
Same answer.
The 2019 Statement of Financial Condition contained false and misleading valuations and statements. Is that correct?
Same answer.
You knew at the time it was finalized that the year 2019 Statement of Financial Condition contained false and misleading statements. Is that correct?
Same answer.
In preparing the 2019 Statement of Financial Condition, Mr. Weisselberg and Mr. McConney worked at your direction and followed your instructions to inflate asset valuations on the Statement of Financial Condition by employing false and misleading assumptions. Is that correct?
Same answer.
Others in the accounting department also worked with Mr. Weisselberg and Mr. McConney to follow your instructions and inflate asset valuations on the Statement of Financial Condition by employing false or misleading assumptions. Is that correct?
Same answer.
Mr. Trump, the court reporter has handed you a document that has been designated Exhibit 30. It bears the production number DB NYAG 248537. Has a title Donald J. Trump, Statement of Financial Condition, June 30, 2020. This is your Statement of Financial Condition for the year 2020. Is that correct?
Same answer.
You approved this document before it was issued. Is that correct?
Same answer.
You reviewed the valuations and valuation methods contained in this document before it was issued. Is that correct?
Same answer.
This is, we'll stop there actually, and we'll get into the document. Oh, Samantha, could you put up, is it? Samantha has put up on the screen a document that bears the production number Mazars NYAG 00162291. Do you recognize the form of this document?
Same answer.
This is the supporting data spreadsheet for the 2020 Statement of Financial Condition. Is that correct?
Same answer.
This spreadsheet was used to calculate the valuations contained in the Statement of Financial Condition. Is that correct?
Same answer.
You reviewed this document with Alan Weisselberg before it was finalized as part of the 2020 Statement of Financial Condition. Is that correct?
Same answer.
You reviewed and approved the valuations and valuation methods contained in this document before it was finalized. Is that correct?
Same answer.
So the 2020 Statement of Financial Condition contained false and misleading valuations and statements. Is that correct?
Same answer.
You knew at the time it was finalized that the 2020 Statement of Financial Condition contained false and misleading statements. Is that correct?
Same answer.
In preparing the 2020 Statement of Financial Condition, Alan Weisselberg, Jeff McConney, and others worked at your direction and followed your instructions to inflate asset valuations on the Statement of Financial Condition by employing false or misleading assumptions. Is that correct?
Same answer.
That's 31, yeah. Mr. Trump, the court reporter has handed you a document that has been designated as Exhibit 32. It has the production number DB NYAG 405109. It is entitled Donald J. Trump Statement of Financial Condition, June 30, 2021. This is your 2021 Statement of Financial Condition. Is that correct?
Same answer.
You approved this document before it was issued. Is that correct?
Same answer.
You reviewed the valuations and valuation methods contained in this document before it was issued. Is that correct?
Same answer.
Sam, would you pull up the next document, please? Yep. Mr. Trump, Samantha has pulled up onto the screen a document that has the production number TTO 061-66407, and we will designate this as Exhibit 33. This is the supporting data spreadsheet for the year 2021 Statement of Financial Condition. Is that correct?
Same answer.
This spreadsheet was used to calculate the valuations contained in the Statement of Financial Condition. Is that correct?
Same answer.
You reviewed this document with Alan Weisselberg and your son, Don Trump Jr., before it was finalized as part of the 2021 Statement of Financial Condition. Is that correct?
Same answer.
You reviewed and approved the valuations and valuation methods contained in this document before it was finalized. Is that correct?
Same answer.
The 2021 Statement of Financial Condition contained false and misleading valuations and statements. Is that correct?
Same answer.
You knew at the time it was finalized that the 2021 Statement of Financial Condition contained false and misleading statements. Is that correct?
Same answer.
In preparing the 2021 Statement of Financial Condition, Mr. Weisselberg, Mr. McConney, and others worked at your direction and followed your instructions to inflate asset valuations on the Statement of Financial Condition by employing false and misleading assumptions. Is that correct?
Same answer.
Can we go off the record?
We're going off the record at 2 p.m.
I'm just going to get some water.
We're back on the record at 2:04 p.m.
Mr. Trump, for each year from 2011 to 2021, did you or someone acting at your direction sign, actually, let's strike that question. Mr. Trump, for each year from 2011 to 2020, did you or someone acting at your direction sign an engagement letter with the Mazars firm to prepare the Statement of Financial Condition?
Same answer.
In the year 2021, did you or someone acting at your direction sign an engagement letter with Whitley Penn to prepare your Statement of Financial Condition?
Same answer.
For the years 2011 through 2020, did you or someone acting at your direction sign a representation letter to the Mazars firm concerning the accuracy of the statements in the Statement of Financial Condition?
Same answer.
For the year 2021, did you or someone acting in your direction sign a certification letter attesting to the accuracy of the Statement of Financial Condition for the Whitley Penn firm?
Same answer.
We had, do we want to do them? Yeah, do tab 64. Mr. Trump, the court reporter has handed you a document that has been designated as Exhibit 34. It is a certification to Deutsche Bank from you, Donald J. Trump, dated November 11, 2014. If you could take a look at the second page of this document. Is that your signature on page 2?
Same answer.
If you look at the first bullet point under point number 1, it says attached here too is guarantor's statement of financial condition as of June 30, 2014. Were you aware that this submission of your statement of financial condition was a material term of your loan with Deutsche Bank?
Same answer.
If you turn to the second page, under point 6, it states all of the representations and warranties made by guarantor under section 9 little I to 9 little 4, 6, and sections false assumptions. Is that correct?
Same answer.
You knew at the time the valuation was submitted to the IRS that the Seven Springs appraisal incorporated intentionally false assumptions about the development timeline for the site. Is that correct?
Same answer.
You knew at the time the valuation was submitted to the IRS that the Cushman appraisers adopted these assumptions intentionally to inflate the value of the easement donation. Is that correct?
Same answer.
You knew that inflating the appraised value would increase the tax deduction available to you. Is that correct?
Same answer.
You knew that your attorney, Sherry Dillon, asked the Cushman and Wakefield appraisers to inflate the value of the easement. Is that correct?
Same answer.
Did you instruct her to get them to reach a higher value?
Same answer.
You were aware that approvals you had received from the town of Bedford, strike that. You were aware of the appraisals you had received from the town of Bedford and its agencies for the development of the Seven Springs site. Is that correct?
Same answer.
You were aware of the restrictions that these approvals incorporated. Is that correct?
Same answer.
You were aware that the approvals restricted the number of lots that could be accessed from the town of Bedford. Is that correct?
Same answer.
You knew that the valuations submitted to the IRS incorporate assumptions that failed to acknowledge development restrictions imposed by the town of Bedford. Is that correct?
Same answer.
You submitted a valuation on the Seven Springs easement to the IRS, knowing that the valuation depended on an inflated number of lots. Is that correct?
Same answer.
You knew that Ms. Dillon would seek to conceal communications related to her work on the Seven Springs appraisal. Is that correct?
Same answer.
Looks like when we were transcribing, I may have talked about approvals from the town of Bedford. I may have muddled it and said appraisals from the town of Bedford.
That's
but
right.
I meant to say approvals. Okay. Mr. Trump, going back to your Doral loan, is it correct that through the use of the inflated statement of financial condition to obtain a favorable interest rate, that you were able to save approximately 6% per annum on interest payments owing on your $125 million in loans from Deutsche Bank?
Same answer.
Regarding your Chicago property, is it correct that through the use of the inflated statement of financial condition, you were able to save at least 4% per annum in the interest payments on loans from Deutsche Bank originating in 2012 in connection with the Trump International Hotel and Tower Chicago?
Same answer.
With regards to your old post office property, is it correct that through the use of the inflated statement of financial condition to obtain a favorable interest rate, you were able to save at least 5% per annum in interest payments on the construction loan of up to $170 million from Deutsche Bank?
Same answer.
Is it correct that absent the $170 million construction loan from Deutsche Bank, you would not have obtained the ground lease on the old post office property or been able to provide the renovation to the property that occurred?
Same answer.
Next question is about apartments held by your daughter at 502 Park Avenue. Do you know if the below market rent that she had on her rental apartments at 502 Park Avenue were provided in exchange for work performed as part of her responsibilities at the Trump Organization?
Same answer.
Do you know if the below market purchase options that you provided your daughter on 502 Park Avenue apartments was made in exchange for work performed as part of her job at the Trump Organization?
Same answer.
Do you know if the benefits from any below market rents were reflected in any tax forms at the Trump Organization?
Same answer.
Do you know if the value of any below market purchase options were reflected as either gifts or compensation on any tax forms at the Trump Organization?
Same answer.
We can go off the record.
Okay.
We're going off the record at 3:12 p.m.
While we're off the record, let's do any of my...
We're back on the record at 3:12 p.m.
Mr. Trump, just back on the record.
And we're, sorry.
As I was saying, we are back on the record to confirm that we have completed our testimony today. Thank you for your appearance.
Thank you. Thank you, Kevin. Thank you, everybody.
Off the record.
Thank you all. We're on the record at 3:13 p.m. and this concludes today's testimony given by Donald J. Trump.
Former President Trump says his 2024 campaign is going
There are new developments tonight in several big Trump cases, and I have a lawyer on hand who is breaking some news. The video you may have already seen glimpses of, although it broke just today, is Donald Trump under oath. This never-before-seen video, new today, in a clash that came from a legal case where, and it's important to remember the context for all the cliches we hear about Donald Trump's delay tactics and strategy, Donald Trump fought this and lost this. The video you see on your television screen is something that he spent a long time trying to avoid, but he lost and cooperated with this New York Attorney General probe, and here's what he said at the start.
Anyone in my position not taking the Fifth Amendment would be a fool, an absolute fool. I respectfully decline to answer the questions under the rights and privileges afforded to every citizen under the United States Constitution. This will be my answer to any further questions.
As for the second part of what he said there, fact check, true. This is a right afforded to people. We will get into that. A.G. James drew these answers from him in what is a civil probe into his finances. This tape is from August. Trump had infamously, memorably, and now hypocritically attacked others who availed themselves of this same right of pleading the Fifth. He went from that to himself pleading the Fifth over 400 times across apparently 4 frustrating hours.
I decline to answer the question.
The 2019 Statement of Financial Condition contained false and misleading valuations and statements. Is that correct?
Same answer.
You knew at the time it was finalized that the year 2019 Statement of Financial Condition contained false and misleading statements. Is that correct?
Same answer.
In preparing the 2019 Statement of Financial Condition, Mr. Weisselberg and Mr. McConney worked at your direction and followed your instructions to inflate asset valuations on the Statement of Financial Condition by employing false and misleading assumptions. Is that correct?
Same answer.
It went on like that, and on like that, and on like that for 4 hours. Now, we could have taken a quarter of that, 25%, for tonight's hour and just played it endlessly. But we are not going to subject you to what the former president was subjected to. In other words, whatever one thinks of the process and the way that some people around Donald Trump, and including Donald Trump, have excessively used the Fifth Amendment to avoid answering questions, it is still the rule of law. It is still something that he fought, was fined, and then eventually had to show up for. That's not the only thing he has to show up for right now. There is a barrage of legal headaches, criminal probes into the coup, into the classified documents, signs in Georgia that the DA is directly saying some more indictments are coming. Whether it's of him or someone else, we cannot tell you. But we know that the DA, which has spent over a year down there investigating a Trump-related probe with a special grand jury, has discussed the idea of announcing new indictments imminently and using that as a reason why she couldn't release more information. In New York, the DA is now convening a grand jury looking at Trump's campaign finances and whether he broke the law in a case long thought dormant, the hush money payments to Stormy Daniels from back around the 2016 campaign. Prosecutors reportedly have begun presenting that case. The New York Times broke that story, and 2 employees at Trump's company, as well as campaign officials and a National Enquirer ex-official testifying. You take it all together, and on the one hand, you could say, Ari, I feel like I've seen and heard this before. Okay, he had to testify a little bit, but he didn't really answer the questions. And Stormy Daniels, that's an old one, and we hear a lot about classified documents everywhere. And you might say, just wake me when it's over, show me when something happens. And that would be fine. Indeed, that could be a mood, a vibe. It's like watching a movie, and you say, I might just fast forward to the end sometimes. You can feel that way. Then there's the reality of our system of rule of law. And the rule of law takes evidence, it takes a process, it takes fact-finding, it uses a very high bar deliberately. And that is the middle of the process we're in. Whether all of these things will eventually lead to more indictments or not, I can't tell you that. But I can definitely tell you that just as Donald Trump ultimately failed to duck the cooperation with the New York Attorney General, and just as many other people failed, like Lindsey Graham, to duck cooperation with the Georgia probe, there's a lot of stuff rising. Now, as promised, we turn to a very special guest we haven't had in a while, who is, well, the man of the legal hour right now. Former federal prosecutor Elie Honig is the author of a new book, Untouchable: How Powerful People Get Away with It. And he's one of those authors who's kept some information in the barrel long enough that there are news articles being written about what was in your book, which is why you're here right now. Welcome back.
Great to see you, Ari. Thank you so much for having me. We have nothing to talk about, right? Nothing happening in the legal world here.
I'm going to get into what's in your book, but first, the point about the fact that James won that round and he lost.
Yeah.
Does that matter, or what do you say to the sort of the cynic that I imagined or channeled here, who says, well, show me the money?
It does matter, Ari. I think you hit the nail on the head. This is the result of our process. Letitia James, the Attorney General, served a subpoena on Donald Trump. He fought it in the courts. He lost. And you know what? He went into that room, he sat in front of the camera, and he testified as one must. Now, he took the Fifth, and you're exactly right. Anyone has the constitutional right to take the Fifth. It was humiliating. I think that's clear. You can see the way the former president is reacting, but he has that right. And I think he's also right when he says in the beginning, his quote is something like, in my position, only a fool wouldn't take the Fifth. He's right, because he does have various criminal investigations swirling around him. And legally, it's important to know this. Taking the Fifth there does have some consequence for him. Of course, that cannot be used against him in a criminal case. That's standard Fifth Amendment. But under New York law, those invocations of the Fifth can be used against him in a civil suit where the jury can ultimately presume the worst. And Letitia James, you know, will use that to her advantage.
Yeah, and that's where when he says, oh, only a fool would not take the Fifth here, the question then becomes, oh, are you the person who knows what you did? You did so much that you think it's better to take the embarrassment, as you call it, a potential humiliation, than tell the truth. We have one other moment we want to play from the deposition. Take a look.
Anything you say in this examination may be used in a civil proceeding, and that can include a civil enforcement proceeding or a criminal action. Do you understand that?
I think.
Is that a yes?
I don't know what I did wrong, but the answer is yes, I do understand.
That goes to your point, and what are many different proceedings. I mentioned some. You've also explored this idea that some prosecutors looked at Trump on what might be called lower level offenses, including the Stormy Daniels case, and said, oh, he's going to get in trouble for bigger stuff, so we should, what, drop it?
Yeah, so first of all, I can't believe we're back at the hush money payments. When you and I met 4 or 5 years ago, this was the lead threat, and now it's back because we're learning now that the Manhattan DA, that is the county level prosecutor here in Manhattan, I should say Alvin Bragg is a friend of mine, a former colleague, who's now the Manhattan DA, is now presenting evidence about these hush money payments to a grand jury. And Ari, as you know, if you're a prosecutor presenting evidence to a grand jury, you are 9/10 of the way to an indictment.
Yeah.
Former President Trump says his 2024 campaign is going to be focused on the future, but there are some grievances he can't just quit.
We're going to restore election integrity. We have to. You go to New York, nobody ever gets prosecuted. I'm the only one they go after. They're sending people that are killers, murderers. They're sending rapists, and they're sending, frankly, terrorists. We have a woke military that can't fight or win, and the wind turbines are all made in China. They said he's not doing rallies, he's not campaigning. Maybe he's lost that step. I'm more angry now, and I'm more committed now than I ever was.
That was not from Trump's first campaign or his second one. That was from last weekend. Several of his allies are telling me that they're worried he's stuck in the past and are concerned about the viability of his third run. Their message to him has been to move forward, tone down his messages, stick to the teleprompter in those speeches. But I'm told he's pushing back on that advice, arguing that he believes his message is strong enough and that he doesn't think any Republicans should actually challenge him for the nomination. Right now, he is having a hard time convincing some people to join his campaign. A source says at least 3 people have been offered jobs on the 2024 Trump campaign, but turned them down, suggesting maybe they'll join later on. No one knows more about these dynamics than CNN's 3 insiders, former Illinois Republican Congressman Adam Kinzinger, Alyssa Farah, who served in the Trump White House, and of course, Congressman Mondaire Jones from here in New York. You saw the message. He said, "I'm angrier than ever." Is that the start to the 2024 Trump campaign, you think?
Like, it was a funny quote, if not totally scary. You don't want your elected officials to be running on a message of, I am angry, and not angry over righteous things, poverty, homelessness, whatever it might be, but angry because of his own personal grievances, that he didn't win the election in 2020. This has been a bad launch from the start for Trump, and...
Why do you think so?
Low energy. I mean, we all watched the launch that day, and it didn't come with a lot of fanfare. It took him over 2 months to even do a campaign event. He can't pull the rally events. You've covered many of them. I've been to many of them. He can't pull the audience he once did. But point of caution, he's still polling the highest. And so long as he has that 30% on lock, I don't see how anyone can beat him.
What do you think of how he's returned to the campaign trail so far? Because it has been kind of a slow start. These were his first really formal events of this year.
Well, he's tired. He's put on some age. I think he's running the same script. There's going to be teleprompter Trump, and then there's off teleprompter Trump. Teleprompter Trump may talk a little bit about the future. Off teleprompter Trump will be all about the past. And I think one of the areas, as Alyssa said with this I'm angry and all this negativity, that works sometimes in an election. It doesn't work all the time in an election. And it's time, I think, as a Republican to say leaders have to start actually putting some optimism out there. When you hear them talk down the U.S. military, look, I disagree with some of the stuff that happens in the U.S. military as a military member. We spend half our times doing computer-based training and not actually training to fight. But we have the best military in the world. We can defeat any enemy. And to listen to the former president talk it down and say we can't defeat enemies anymore, I mean, that's like worse than the old, malaise in America kind of thing.
Yeah, but he is still the front runner as of now. No one else has even declared that they're running, though it's only a matter of time. But I wonder, with this kind of a message, is this something that, with Biden on the cusp of announcing that he's going to run for re-election, that this is going to be a concern for him? Is he worried about anything like this?
I think if you're Joe Biden and you're the White House, you're happy to see this president once again engage in grievance politics that say more about him as a person, his character defects, than they do about the people and the institutions that he's criticizing. When is he going to make the affirmative case for why he should get a second term in the White House? And by that, person, I mean Donald Trump, of course. He's not doing that. I don't think he's capable of doing that. I mean, it turns out a lot of the stuff he wants to do is not particularly popular to begin with, and so he's going to keep trying to divide. But I don't think it's going to go anywhere because he's no different from the guy that voters rejected back in 2020.
Yeah, well, we'll see. That's kind of what his allies have been saying to him, that you need to change your message. But I'm curious, Alyssa, what you think of what Senator Lindsey Graham said last night, because he was asked about the possibility of other Republicans getting in the race. He said he's still betting on Trump.
To all these people who are very talented, I don't think you could do what he did, and I want him to have another shot. Unfinished business. We need to get ready for a real spirited contest. Now, why Trump? Now, you mentioned like DeSantis. If you try to tell me that Ron DeSantis is not a good governor in Florida, I'm not going to listen to you. If you try to tell me Mike Pompeo is not qualified to be president, I'm not going to listen to you because I think he is. I am for Trump, not because of the flaws of anybody else. I'm for Donald Trump because I know what I'm going to get.
Oh, Lindsay, I know what I'm going to get. Does he mean insurrection, trying to overthrow American democracy? Listen, there's some core supporters of his who are always going to be with him, but I do think there's going to be a contest. How big it is, unclear. There are people who are going to put their names in the ring. Listen, if you run as Trump light, this is my concern with DeSantis, who obviously polls the closest to Trump, is he kind of takes up all the oxygen in the room. You have to have a clearly defined lane. This is where some of the governors who are toying with running, an Asa Hutchinson, a Youngkin, a Sununu, I think have a more clear path. They have their own record and their own vision to run on. But again, I caution against the giant field that we saw in 2016 that just cleared the way for Donald Trump.
Can I say something about Lindsey Graham, by the way? So I've
Please
traveled
do.
with Lindsey. Lindsey and I used to be kind of in the same mindset on foreign policy and things like that, kind of, you know, the John McCain way of looking at the world. Where he has gone now, I just completely don't understand. He knows far better than anybody what January 6th was. He knows what Donald Trump isn't capable of, which is true leadership. And for me, it's just so disappointing every day to watch somebody who was frankly talented. I mean, Lindsey Graham was able to really bring people that would be considered independents, maybe some soft Democrats, and he's just gone all in. I don't know his play here, except probably just to survive South Carolina. I mean, look, he wants to stay in Senate the rest of his life. There's nothing inherently wrong with that, but the only way to do that is to make it through a primary in South Carolina. And when the Trump thing goes out of vogue in the party, and it will, maybe it's soon, maybe it's later, he'll go back to being what he needs to be reelected. It's a sad commentary, frankly, on politics.
Yeah. There was this moment that I know I talked to people inside the White House that caught their attention. That is something that Senator Elizabeth Warren said. She was doing a radio interview and she was asked about Biden running again. And she was asked about Vice President Harris specifically and whether or not she belongs on the 2024 ticket. This was her answer.
Should Joe Biden run again for president? He'll be 86 by the time his second term is over. Yes, he should run again. If he's that old in his second term, the vice presidency becomes even more important. Should Kamala Harris be his choice the second time around?
You know, I really want to defer to what makes Biden comfortable on his team. I've known Kamala for a long time. I like Kamala. I knew her back when she was an attorney general and I was still teaching, and we worked on the housing crisis together. So we go way back, but they have to be a team, and my sense is they are. I don't mean that by suggesting I think there are any problems.
That's not how the White House took it. She later put out a statement saying she didn't mean to intend or imply that she doesn't think they're a great team, but that was kind of a moment that wasn't as emphatic of endorsement as people suspected it might be.
You know, I think people are reading too much into it. I think she intended to do what she said initially, which was defer to the president. I don't think that there's any reason that she or anyone else would believe that the president would not run with his vice president for a second term. There are concerns within the party. I mean, that's obvious. And
about what?
I think, you know, people wonder about, you know, her popularity, but the fact is, she won on the ticket back in 2020. If anything, they have more to run on in order to be able to, you know, survive a challenge by Donald Trump, or I think many of the other people like Ron DeSantis who are thinking about running on the Republican side, and I think you'll see that happen.
Does she help or hurt Biden on the ticket?
I think she helps with certain demographics, and then she's, you know, hurtful with respect to other demographics. But ultimately, it's the top of the ticket that matters, especially when she's clearly qualified, unlike a Sarah Palin, who I think was a reason why many people voted against John McCain.
Fascinating times. Mondara Jones, Adam Kinzinger, Alyssa Farah. Griffin, thank you all three for joining us.
There are new developments tonight in several big Trump cases, and I have a lawyer on hand who is.
Yeah, I think in the next 2 years there will be a lot of things and stuff to talk about in American politics. I think, respect to Germany, there are a lot of similarities, and the German conservatives already put in the woke stuff into German politics, same as Americans. We will see how the CDU, CSU will position themselves into the spectrum of German politics, if they want to go the Trump route, or do they want to go into like a more actually conservatism route. But they will have to have a tough time. And other European countries are the same. We will see similarities and differences. Every country, of course, has differences there, but a lot of stuff is happening in the next 2 years, and I think the Trump indictments, or maybe a kind of like a precursor to all this stuff, how this develops. And I think it's really important what happens there. And actually, because of Trump, it's funny, even if it's kind of not funny because of the seriousness of the situation. So we will see. I will cover most of it, I think. I try to give a broader picture, because like a 2-minute news clip is not what happens, and every news organization, every single video gives you a little bit more of a complete picture. So yeah, we will see, and a lot of stuff is going to happen.